Good morning, everyone, and welcome to today's panel discussion for the Evolving U.S. Federal Digital Accessibility Legal Landscape. And at this time, please welcome disability rights lawyer and author from the Law Office of Lainey Feingold, Lainey Feingold.
Okay, good morning, everyone. Thank you for joining our session on the federal regulatory and legislative legal landscape. We have an amazing panel here who will introduce themselves in a minute, and we have a ton of content to share. Just want to set a little stage for why we're talking about the federal legal landscape at an accessibility conference. So we all know that accessibility is design and development and training and every single thing each of you do, policy and testing and international work. All of what you do in your jobs is accessibility. Why is law part of accessibility? Because accessibility is a civil right of disabled people. Accessibility is a human right of disabled people. And when we talk about the law, sometimes we forget that bigger picture. And I want to say that first, so we can all hold on to that as we dive into the details of what is happening. The other stage-setting thing I want to say is that yesterday, I won't name the person because maybe he's changed his mind since then, said on the stage, oh, let's get the boring law part out of the way and so we can get to the fun stuff. So I just want to give another frame for how to think about the law, in addition to the fact that digital accessibility is a human and civil rights. At the Microsoft Ability Summit in 2021, a woman from Kenya, Lizzie Kiama, said, the legal framework gives us the possibility to dream. The legal framework allows us to dream what is possible. And here in the United States, we are so lucky to have already a framework that gives disabled people rights to dream what is possible in the digital space. So we're going to talk a lot about how to make that better, how to make that stronger. We know that law should be faster, it should be quicker, it should be clearer, people shouldn't abuse it, all those things. But big picture, we have civil rights laws that give us the permission to dream. So with that, I want to ask our panelists to introduce themselves, starting with Eve and going down the line. Eve.
Hi, I'm Eve Hill. I'm a disability rights lawyer. I've been a disability rights lawyer for a long time now. But I am currently a disability rights lawyer at the law firm of Brown, Goldstein, and Levy in Baltimore and Washington, D.C. I'm also the founder and principal of Inclusivity Strategic Consulting. So I will both help you if you want to do the right thing and sue you if you don't.
Who could be better?
What a great tagline, right?
Sachin.
Hard to follow Eve right after that. Sachin Pawitan, Executive Director with the U.S. Access Board, blind immigrant, been working in the space of accessibility for a long time now. Advocate at heart and love the work that needs to be done, but also enjoying the conversation we've been having about AI and everything else.
Anil?
I'm Anil Lewis. I'm the Executive Director of Blindness Initiatives for the National Federation of the Blind. I don't really know why I'm on this panel. No, I love adding the voice of the 50,000 members of the Federation to these discussions because we're talking about issues that will help blind people live the lives we want.
And Jennifer.
Jennifer Mathis. I am currently a Deputy Assistant Attorney General in the Department of Justice Civil Rights Division, which I call the Eve Hill position because Eve had that position before I did during the Obama administration. And like Eve, have been a disability rights lawyer for a long time, longer than I care to remember, but something around 30 years or so. Happy to be here.
And this all reminds me of two things. Sachin said it's hard to follow Eve. I wanted to start by saying, wow, Utah. I hope just wow, Utah. Like, I don't know if Utah's still in the room, but oh yes. All I could think was like, how lucky are we to have like Utah in our camp doing this work. I just was, and I knew that every word out of your mouth was a million other pages behind it with information and data and stories. So thank you so much for that. And I forgot to introduce myself. I'm Lainey Feingold. I'm a disability rights lawyer also. My hair is a lot grayer than anybody's up here, so I have probably been one for longer than anyone else. Since 1995, I've been working in the digital accessibility legal space. I've written a book about collaboration in advancing accessibility, and I do a lot of public speaking. I really thank the organizers, G3ICT, for having this session, having me moderate it. So what we're going to do in sort of lightning speed, because there's a lot to cover, we're going to talk about what's pending new legislation. We're going to talk about what's pending possible, let me back up. What's pending possible new legislation? What's pending possible new regulations? What else is the federal government doing besides regulations to help us all as we advance accessibility? And what is happening on the ground in the federal space around digital accessibility in the law, given the laws we already have, which is a lot. This afternoon on the live stream, Eve and I will be doing a really speed dial talk for 15 minutes about what's happening on the state level in the United States. So that's a plan for today. So we're going to start out with the pending federal legislation. And the first one we had here was the Communication Video Technology Accessibility Act. I think I had Jennifer, but then Jennifer said, no, I don't really want to talk about the pending legislation.
I don't think I can.
Yeah, so there was a great session here yesterday on the CVTA, which is, I'm not going to go into too many details, except to say that I listened to the session, and Larry, who's in the front row here, could get up here and give us another hour on the CVTA. But I'm just so happy that people are working to make the CVAA better, the 21st Century Communication Video Accessibility Act. So this new version of it, which I really encourage you to look online, there's a lot of good resources, will improve accessibility for communication and video technology for deaf people, blind people, and really everyone. And that was the message I got from yesterday, making sure caption quality is better, so many things that are, the CVAA was 10 years ago. And like I said, the law is not as fast as we need it to be in the digital accessibility space. But it's wonderful that the CVTA is on the horizon. It has been reintroduced. Someone asked at the end of yesterday's session, how are we going to get this thing passed? There's like so much goodness in it. And Karen Feldstrauss said, you just watch us. We're going to get it passed. And Karen, I don't know if you're in the room, but she rattled off every single communication video accessibility law that's been passed for the last 25 years. She said, we did that, and we're going to do the CVTA also. So that is the first thing that's on the horizon, which impacts all of us. So I really encourage you to look at that. The next one that's pending, again, we're talking about pending, is the Website and Software Application Accessibility Act. And for that, I'm going to give it to Eve or Anil to
That's Anil.
kick it off. Anil.
Well, the thing I'll say, piggyback on what you were saying about the CVAA, is I love the fact that Cross Coalition of Disability Organizations are very actively involved in the development and implementation of this legislation. For far too long, things have been done on behalf of people with disabilities, and voila, here, look what we did for you, and then we have to have feigned grace and appreciation. But I love the fact, again, building on the panel from yesterday, that evolving legislation with that full participation is happening, and I'm very excited about this legislation because websites, software applications, they're just becoming the way that we access information. I had the opportunity to testify on a panel, Eve and I. We seem to be running into these places all. And talking about the virtual front door. And I think that it's very important that we recognize that just as we, as people with disabilities, finally got used to how we can maneuver around the existing doors, which weren't accessible, but we found strategies because we adapt, that's what we do. Those particular avenues of accessing services and information are being closed. and we're being forced to go into a new area of accessing information that is inaccessible. It's like once we get to a place where we finally made some progress and we're finally getting to a place where there's some equity involved, the game changes. But what we have done as a community of people with disabilities is we've gotten savvy enough to adapt progressively and ongoing. So we're trying to get ahead of this at the point where it's going to be important for us to be very vocal in this process. And there's 264, and I guess we'll talk about that when we get more to the regulatory piece of it, cross-disability organizations that are watching this progress forward. But I'm happy that we are actively engaged in those discussions. We're meeting with our policymakers on the Hill. We know no one likes to see the sausage gets made, how the sausage gets made, but we're actively making some sausage. And we are committed to making sure that once that meal is served, that people with disabilities are at that table enjoying the meal just like everybody else.
And there'll be something for vegetarians too.
There's veggie sausage.
Not just sausage. Yeah, veggie sausage.
Yeah, sausage is okay.
So one thing about the Web Accessibility and Software Act, one difference I know about is that it would bring developers into the legal frame. Someone want to say something about that?
That's right. We get a lot of complaints from the folks that we help through the courts, and that it wasn't mine. I bought it from somebody. They gave it to me. I thought it would be accessible. And I have not very much sympathy for that, but it's important that they have abilities to go after their developers, and that we also have the opportunity to hold responsible the people who actually originally created the problem. So the Web Accessibility Act would allow people to pursue the developers who make the inaccessible website and really put the blame and the liability where it originates.
Now, one thing about these proposed pieces of legislation, we already have the ADA, and the ADA is so crucial to that framework that makes dreams possible in the United States. So we're trying with both of these laws, the CVTA and the Website and Software Application Accessibility Act, adding to the disability community's alphabet soup of new things we have to learn to remember all these laws. You know, we have laws that already cover websites, and there are also ways to bring in developers sometimes, and that's being done. But what these laws do is make it stronger, make it clearer, but it's really important not to think, oh, well, there's these 2 new laws I heard about at M-Enabling, so I'll wait to see what happens. This is not waiting to see what happens with new legislation. It's letting you know that new legislation is on the horizon, hopefully will be passed, and to double down on making sure the legislation that we have is enforced. So is there anything else anyone wants to add about either the CVTA or the website software accessibility? Okay, so in addition to the proposed legislation, there is a lot going on with proposed regulations. So the law is one thing, the regulations is what make laws happen. So one part of making laws happen. So the first pending regulation that we want to talk about is the, not surprisingly, ADA Title II Web Accessibility Regulations. Who better to talk about that than Jennifer?
Okay. So I think I'm supposed to talk about the proposed rule in 2 minutes. How
about 3?
Maybe 3, okay. So I will do my best with that. I will give you a very, very, very high-level summary. So I think certainly the biggest takeaway is that the technical standard that the rule proposes that state and local governments adopt for their websites and mobile apps. The rule applies to both, a proposed rule applies to both websites and mobile apps, is WCAG 2.1 AA. There have been sort of comments on all ends. I can comment a little bit about the comments, but some people saying, oh, that's too advanced, you should do 2.0, and other comments saying you should do 2.2. Anyway, but it is currently in the proposed rule 2.1 AA. That is sort of the standard that a state or local government would have to ensure that its websites, mobile apps that uses to deliver its programs, services, and activities meet that standard, unless it's an undue burden or a fundamental alteration. Those are standard ADA defenses. There are also a number of exceptions, and there are exceptions to the exceptions. So it's a little complicated, but the exceptions are generally designed to try to get at content that people with disabilities wouldn't actually be using, and they, I think, do or don't get at some of that content. The lines are not perfect, and that is why we have proposed rules where they're open for comment, feedback that can be taken back for consideration in a final rule. But for example, I'll give you a couple of the exceptions. So there's an exception for archived content. And I noticed in the comments, I think there's a lot of misconceptions about the scope of the exceptions. The exceptions are all intended to be very narrow. For archived content, web content that would meet all three of the following factors would not need to comply with the WCAG 2.1 AA standard. If the content is archived and maintained only for research, reference, or record keeping, and the content is kept in a special area for archived content, and the content has not changed since being archived, that would make it archived content that is accepted from the 2.1 standard. However, the ordinary reasonable accommodation, reasonable modification requirements apply, effective communication requirements apply. If a person with a disability needed access and was, say, doing research on an archive and needed to use that material, would make a request for a reasonable modification of having materials made accessible. And so that person would, through the ordinary obligations under the ADA, be able to get those materials made accessible through a reasonable modification request, unless it was an undue burden. So those things still apply, and I think it's important for people to understand that throughout this regulation, we tried to make clear, I think we could make even clearer, that the standards that apply now still apply. So even though this sets a technical standard which would not take effect, if this rule does go into effect, the technical standards wouldn't go into effect for 2 years, and for very small entities, 3 years. In the interim, it's not like there's no, the ADA stops applying to web accessibility and mobile app accessibility. Right now, the Justice Department is enforcing web accessibility requirements, and private litigants like Eve are enforcing web accessibility and digital accessibility requirements every day. And so there isn't a technical standard that the government has adopted. However, courts have kind of looked at this and looked at the standards that exist. And in many cases, courts have said, you need to comply with 2.0 or 2.1. And we have settlement agreements that say you need to comply with 2.0 or 2.1. And so that all applies, even in the absence of a regulation, continues to apply even before a regulation takes effect. So I think that's important for people to understand. And we'll just talk briefly about one or two of the other exceptions, just to keep this within the time frame. I'll talk a little bit about these education exceptions. I think these are the ones that have gotten the most comments. An exception for password protected course content, one for K-12 education, not the learning management system itself. So say like Canvas or something for elementary school kids, or other platforms, edX for college students. Not the platforms themselves, but the course content. So if you have a class where you actually did not have a student with a disability, and this content was specifically for this class, not for the public, so not something like a MOOC or course content open to the public, but specifically for this class and password protected, and you actually didn't have a student with a disability in the class, or for K-12 students, you didn't have a parent with a disability who needed access, then in that case, the material could be accepted from having to comply with the standard. The theory being nobody actually would need the material to be made accessible. But as soon as there is a student with a disability enrolled in a course and that kid does need accessibility, then within 5 days, all the material needs to be made accessible for kids with all types of disabilities. And for higher ed, the parent piece does not apply. So for K-12, it's a student with a disability or a parent with a disability. For college and university post-secondary institutions, it is just if a student with a disability needs the material to be accessible, then it has to be accessible. And so anyway, I will say that with the comments, there were a lot of comments on that, comments saying, 5 days is not workable. There were comments I thought that were interesting from higher education groups essentially saying, we don't think we can do 5 days here, but essentially you should have universal design. So essentially make us do it all the time because we can't go back and forth between not doing it and doing it.
Makes sense.
Yeah, makes sense. So, and obviously, there are many comments from disability groups that said, get rid of the exceptions, that, and highlighted issues with particular exceptions, but also said, eliminate exceptions. You have the undue burden fundamental alteration defenses. That should be sufficient to address the issues and concerns. So, don't have these exceptions, just use those defenses. You had comments from state and local governments, including also in listening sessions that we heard saying, this is all too much and we can't do this and you should have more exceptions, or you should have broader exceptions, or you should have the effective dates be much longer than 2 years or 3 years. You should have 4 to 6 years for small entities. You had disability groups saying 6 months. And so lots of comments from, I think, across the spectrum around the same issues, but with somewhat different takes. So that's my high-level summary of the comments on those.
Yeah, thank you. I should have said at introducing this topic of the Title II regs, the status. So for the rest, I'll try to get the status right. The status is that the Notice of Proposed Rulemaking, which is NPRM, has been out. The comment period is now closed. The DOJ has it in their hands to go through all the comments and come up with the next step, which is hopefully a final rule that everyone feels good about. I know Jennifer covered that already the ADA, our strong piece of legislation, gives rights and protections to state and local government digital properties. And Eve does a ton of work on that. You want to just give one example of how the current ADA is working without these regulations? Let's make believe they never happened.
Sure. Well, one example is the Domino's Pizza case, where Domino's Pizza was sued for not having an accessible website, and that went all the way through the courts, like all the way through the courts, almost to the Supreme Court. And it was found that Domino's needed to have an accessible website, and Domino's now has reached an agreement where it will have an accessible website. So those
And that
things
is
have been
Title
happening.
III.
And that is Title III.
Which is not even mentioned in the current.
But in Title II, recently, the Justice Department, for example, has reached a settlement with UC Berkeley to make all its educational content accessible. And we went through litigation with the Los Angeles Community College District to demand that all its course content, databases, learning management systems, et cetera, all be accessible. And the jury on that case, on the second time that went to trial, awarded over $200,000 in damages to our 2 students, and we're now waiting for the judge's order on what the injunctive relief will be. So these things are happening even in the absence of a rule. The ADA continues to apply, continues to really require significant accessibility requirements of covered entities.
Another example, we need to know this stuff, we want regulations, and we can't wait because the existing framework already requires it.
So
Next.
may I, before you transition?
Yes, Anil.
So several things really quickly. Everybody in this room, if you consider yourself an industry expert, should be offended by exceptions, because they're counter to what we know is true around accessibility, right? So, I mean, in all the examples that you can think of, well, first and foremost, it goes to be restated. It already exists that there's an ability for undue burden and a fundamental alteration. The only reason I like those is because that requires the entity to have a roadmap for meeting the expectation. If you give them an exception, that goes off the radar. So that's just unattainable. The 264 organizations I referenced earlier, no exceptions. Just doesn't make sense. Microsoft is making Xbox games accessible to blind people to play video games. It shouldn't be difficult to make it possible for people with disabilities to access public information, Social Security, housing. I'm sorry. I know that it's closed, but we're going to be calling on you guys in the future that when these opportunities exist, we need you to be echoing, to make your comments as the professionals that you are, recognizing that this is just going to take us backwards. I'm all about the rational, incremental progress that government makes, as long as it moves forward. But if you start trying to take something away from me that I fought so hard to get, I'm going to raise hell about it. And I want you guys to help me raise hell about it.
Thank you. Thank you.
I'll behave now.
We have a great panel, don't we? We do. I see a hand up. We are going to leave room at the end for questions, but we want to get everything out on the table, so we're going to pass on the questions right now. But thank you for having a question. You'll be first up when we get to the questions. Okay, so we're on the big topic of what's pending in the regulations. The next one I want to mention is Colin Sachin to talk about the self-service transaction machines, formerly known as kiosks, or currently known as kiosks also. So Sachin, could you start with the status and then, talk about where that's at?
Before I jump into the self-service transaction machine, I appreciate the comment that Anil just made. Yes, exemptions is not something that that's not something we want. But I also want to recognize there is a process that we go through in the rulemaking process in the federal government. And I want to recognize all the public comments that has come through for the Title II. Obviously, I'm not part of DOJ, and I haven't seen those comments, what the conversation is going on within DOJ about those comments. But it is an important process that informs what the future of that rule looks like. What you saw, the NPRM is not the final version. It is something that was proposed, but the public comment does play a role in what that future rule is going to shape into. So I don't want to make it look like it's done. It's not a done deal yet, but it is important to also stay on top of where that is going. I'm not saying that we don't have to stay engaged, but I don't also want to shape it that it's doomsday either. So, with that said, self-service transaction machine, the Access Board, we are engaged in multiple rulemaking. As a small agency, the number of rules we're undertaking under the current administration, it's pretty large for our agency our size. So self-service transaction machines, all kiosks, has there's a lot going on in that space, especially since COVID hit. We are seeing kiosks in every kind of transaction spaces that you might imagine. We had an ANPRM come out earlier this year. We've received public comments. And right now, we are in the process of getting our NPRM out for the self-service transaction machine. I can't give a specific date when that's going to come. Our hope is to have NPRM out early 2024 for public comment, which I hope there'll be engagement from the community, both industry and consumer organizations. So because we want to hear from you, because that's what informs us on what that final rule is going to look like. So stay tuned on what's coming down the pipe. Our goal is to have that rule finalized, hopefully, again, fingers crossed, by the end of this term of the administration. That's the Biden-Harris administration.
Yeah, so for people not totally familiar with all the alphabet soupness of it, so the Access Board has already issued and taken comments on the ANPRM, which is the advanced notice of proposed rulemaking. Next up is the notice of proposed rulemaking, and after that is the final rule. So I just want to say also that this kiosk self-service transaction machine topic is another one where we can't wait.
We're not waiting.
What?
We're not waiting.
We're not waiting. And, we have so much to say, but I just want to say many of these topics I write about on my website, and I do, which is lflegal.com. And I have a kiosk article that says kiosk, so laws paying attention. And I put in there whenever there's an update to what a new case, probably something that Eva's been involved with, or the NFB. There's been a lot of structured negotiation and litigation and great work from industry making kiosks accessible. And there's vendors here at this conference showing their accessible kiosk work. Just last Thursday, there was a really important, good decision out of a federal court in Los Angeles saying that the Quest healthcare kiosks that you check in on the blood draw thing have to be accessible. After, I think they had a trial.
They did.
They had an actual trial in LA. So this is happening now. We want the regulations, Sachin. We're not saying we don't need them. We need them, we want them, and we can't wait. So yes, thank you for that. Next up is Department of Ed updated 504 regs.
Yeah, so both the Department of Health and Human Services and the Department of Education are planning to issue updated Section 504 regs this year. HHS has its NPRM out, Notice of Proposed Rulemaking, out right now and open for comments. It's only 400 pages long, so I encourage you all to read it with great detail. But it has a lot of really important things in it. It covers medical equipment accessibility. It covers non-discrimination in the child welfare context. It covers non-discrimination in the decisions to provide treatment, such as organ transplants. All very, very, very important things. And then the Department of Education, similarly, its reg under Section 504 hasn't been updated in decades. And their plan is to get a Notice of Proposed Rulemaking out this year. I hope that happens, I'm knocking on wood. But that will be another opportunity to cover all those entities that receive federal financial assistance. So that's a lot of state and local governments, but it's also a lot of private entities that get federal money that will need to comply with these standards.
So when these come out, we just want to say here that the public comment, which everyone in this room has the right to make, is really important because, like Sachin said, it's called a notice of proposed rulemaking because it's not the final rule. So when these things come out, and at the end, we're going to give you some resources to stay current on this since things are happening fast and furiously. But we all encourage everyone to put in their comments because that's what makes a difference. I mean,
And the
Anil,
HHS one is already out, so people should comment.
Now.
So.
now, go home, put a note in, put in your calendar for next Monday. Okay. Okay, back to the Access Board, electric vehicle charging stations, which is like really important to the whole infrastructure of getting electric vehicles on the road. Sachin, what's the status of that?
So last year, we issued a technical requirement document on EV charging. Obviously, we are seeing EV charging stations popping up everywhere. And within the current, the infrastructure bill that came out about a year or so ago, there's about $5 billion for 500,000 EV charging stations dollars being sent out for installation of EV charging stations around the country. So obviously, we want to make sure EV charging stations, which currently are not accessible, be accessible when these federal dollars are being sent out for building new EV charging stations. So the technical requirement document that was put out last year by the Access Board, gives a pathway on what industry can do to make sure that accessibility is followed when installation and when these EV charging stations are being manufactured. But we are undertaking our rulemaking on this as well. The schedule on this one is a little sooner than the SSTM rule. Our hope is to have an NPRM by the end of this year, so that, again, one public comment on that, with a hope to wrap up that rulemaking by mid. Again, I hate to give a definite date, but
We're writing it down, too.
mid next year sometime. So again, there's a lot.
I like it.
Yeah, keep laughing.
Anil's taking notes over there, so you better.
I'm going to get calls from Anil. I checked on the date. It's on his calendar. But yeah, so the goal is to get some of these big rules done by the end of next year. But again, yes, this is going to be out for public comment by the end of the year. Real hope is to have, the feedback from all of you, so that that final rule shapes the way the public and the industry is wanting it to look like.
Nice.
Okay, so there's also an NPRM out from the FCC, the Federal Communications Commission, on video conference accessibility. Again, video conferencing already has to be accessible. This rule is primarily, it's about a lot of different things, but primarily the way I understand it, it's about technical standards and diving deeper into the standards. Karen, do you remember, is that closed already?
No, it's open. The FCC generally sets functional standards.
Functional, right.
For performance, what are called performance standards. They stay away from technical standards.
Okay, so that NPRM is open, and I do have an article about that on my website with links to how you can file comments.
Actually, I'm sorry. I think the comment period is actually closed, but you can always file late file comments or ex parte comments, and they will accept them right up until they deliver the proceeding pretty much.
Okay, so the comment period is closed on the FCC video conferencing NPRM. However, no one knows more than Karen here, and she says that you can still file late comments, and I encourage you to take a look at that and do that. And like I said, I have an article on my website about that. So that's it for the proposed legislation and the proposed regulations. We want to speed us up a little bit so we have plenty of time for comments. We want to talk a little bit about some federal agency work that isn't regulations, that it's hard for the public to know this stuff. I mean, that's one thing. We're going to do the resources at the end, but in case we run out of time, I really want to encourage everyone to get on the email list of both the Access Board and the Department of Justice and the FCC, because they send information, and you find out about these things before the comment period is closed. So I think the agencies do a good job at trying to get the word out, but there's a lot. So that's a good way to follow it. Okay, so the first one we want to talk about is the AI hiring tool guidance, which is from the DOJ and the EEOC. Jennifer.
So this came out in 2022. It is specific to the use of algorithms and artificial intelligence in hiring, and the ADA's application to that. There are actually two separate guidance documents. It wasn't a joint guidance, it was sort of a joint effort between the Justice Department and EEOC. So EEOC's guidance is more in the weeds. It is longer and more detailed in certain areas, and it was really aimed, I think, more at vendors who are producing and designing and selling this AI technology that is used by employers in their hiring. The DOJ's is a higher level document. They were intended to kind of be companions. That's more of a sort of high level know your rights in this area and know your obligations in this area. And so DOJ's, it's pretty short. It's on ada.gov, which is now redesigned, and it's easier now to find things than it used to be. But this guidance basically talks about different ways that the ADA applies in this area, talks about what counts, what kinds of algorithms and AI are being used for hiring purposes, and how they may end up screening out people based on disability, talks about the different obligations you need to think about, like does the AI screen out, does the tool that you're using screen out people based on disability when that's not necessary? Does it measure effectively somebody's disability rather than measuring their skills and abilities for the job? And reasonable accommodation obligations. And so talks about all of those things, gives some examples and some also practical suggestions for employers on what to do to make sure that you're not violating the ADA, including things like also just telling people when you are using AI or an algorithm in a hiring tool, so that people know that they may need to request a reasonable accommodation, which might be a different hiring methodology for them. It might be changing the tool, providing clear procedures for requesting reasonable accommodations, and making sure that requesting one doesn't hurt somebody's chances for the job, and that they know that.
Jennifer, we did agree in advance that we can cut each other off if we're
great.
running on the
Done.
time. So we want to make sure we at least hit everything so you can all follow up. So with apologies.
I'm done.
Okay, good. I do have a plain language article on my website about this guidance, so there's that. There's also the telehealth guidance from the Department of Justice and the Health and Human Services that really talks about the importance of accessibility in telehealth, COVID vaccine portal things, a lot of health work. Again, I have an article on my website where I gather all the resources. We can't wait on this. Of course, it's healthcare, it's life and death, and already the ADA already requires it, and there's a lot of great work already being done. So that's what we'll say about healthcare. Eve, you want to say something quick about the ed tech, the DOE and DOJ?
Yeah, Department of Education and Department of Justice released a Dear Colleague letter to higher education institutions explaining to them that schools are responsible for the accessibility of their own web presence, as well as the third-party platforms and content that they use on their websites, and the content that they provide as well. So that was, again, another reason we have the information to pursue this. We have it in guidance, we have it in court cases. We don't just need the regulations.
And it emphasizes also coursework that's open to the public, not just courses for enrolled students in the university. So.
Sachin, do you want to hit 1 minute on the 508 assessment process, which is also part of the regulatory federal scheme?
Sure, yeah. Obviously, there's been a lot of spotlight on 508. I'm glad Congress is paying attention to the lack of implementation of 508 that still exists. Last year in December, there was the Consolidated Appropriation Act, which required OMB to work with the Access Board and GSA to create an assessment criteria so that federal agencies can assess themselves on their conformancy on 508. That all agencies were supposed to get all their assessments done by August of this year, which has done, and I was pleasantly surprised. We had a significant turnout as far as the data that we received. Right now, GSA and Access Board is looking through the data, and the report back to Congress is due in December. I'm not going to be very surprised with the data. I'm sure that, I think most of you will know that the data is going to show how bad the implementation of 508 is. My hope is this is a roadmap to what Congress can do to make sure 508 is taken seriously in the federal government.
And I would just say with that, there's a recent Court of Appeals decision in DC that says that people have their own private right of action to enforce Section 508. So that one of the reasons why implementation has been so lacking is because the enforcement mechanism has not really been clearly there. So this may really make a difference.
Which is a great segue into the last section, which we don't really have time for, but I'll let Eve say a couple things on. We've scattered it throughout that these laws are the laws that exist, Section 504, the Americans with Disabilities Act, other state laws that Eve and I will talk about on the live stream, they're being enforced now to protect the access to digital accessibility rights of disabled people. They're protecting the civil rights of disabled people now. We want to do a couple cases. I'm going to throw out 30 seconds on my favorite, which is a case that said that a library of VR software has to have captions for people who are deaf. It's the first VR case.
Virtual reality, not vocational
Virtual
rehabilitation.
reality. Oh my God, I'm the one who hates abbreviations. Virtual reality, which was kind of reassuring because the law is so slow and we're still talking about websites. Oh my God, the technology is moving faster. Eve, give us a couple good cases and then we'll close.
Sure. So as Jennifer mentioned, the DC Circuit decided the Orozco case, which said that federal employees have a private right of action to enforce Section 508 against their agencies. So now you are seeing, or you will soon see, a lot more enforcement activity in that space. In addition, the EEOC just last week filed a case against NTI, which is an agency that hires folks to do customer service for other companies, and they were refusing to hire blind and low vision people because they said that their company customers' software was not accessible. And so the EEOC is suing NTI for covering up the discrimination of
Bad
their
acting.
of their customers. So that's going to affect both the technology accessibility requirement enforcement, as well as who's responsible for making sure that no discrimination happens in that chain. There's also a false claims case in California, so there is money here. If someone designs an inaccessible website, sells it to a state or federal government, and gets caught with it not being accessible, they can have to turn back in the money that they got paid, including the bounty to the person who finds out that the website was not accessible. Wow. So that's what that case will stand for. I hear it's been settled, but I have not seen the settlement agreement yet. So there are still big things happening in this space, even while the federal government's guidance and regulations roll out.
Skip law.
Yeah.
Yeah. Okay, so that's a tiny little taste of what's happening on the ground now. If you like this kind of thing, I just want people to know that first week of December, I'll do 2 hours with 3Play Media on the digital accessibility legal landscape. So if you want more law, 3Play Media is here as a sponsor. How to keep up, I already said Access Board and DOJ has an email list, and FCC that's really good. Also, they're on social, DOJ, Access Board, NFB, Brown Goldstein, me, LF Legal, and Safar Shah has a blog where they keep up with the legal things. I rely on all these sources to stay on top of things. And that's what we got. So I want to thank the panelists. I want to open it for questions. We have, according to the countdown clock, 6 minutes and 45 seconds. So try to state your question briefly and we'll try to answer. Oh, and the first question goes to the woman in the front here who patiently had her question earlier.
I'm Sandy Hannabrink. Thank you all for the update. My concern is, I guess, the same as NFB. These standards go in place. How does that weaken the ADA and Rehab Act when they're putting exceptions in place for things that should just be happening? I mean, it's been 50 years and 34 years. Why are we even considering exceptions?
Well, that's an excellent question. One asked by many of the comments from the disability rights organizations. There are already defenses, the undue burden and fundamental alteration defenses, and those have the benefit of responding specifically to the situation, how difficult it is to make something accessible, and the resources of the covered entity that needs to make it accessible. So those are useful for the covered entity and less of a blanket exception for people with disabilities. And so the questions that I think are raised by the disability groups commenting on the regulations, sorry, Jennifer, are why do we need these blanket exceptions for things like that include new content, for heaven's sake, and that are permanent exceptions, no matter how AI develops and makes things so much easier to be made accessible even after the fact. No matter how the technology develops, these permanent exceptions will be in place and roll us back from things that are already required even by the Justice Department.
And then the other piece that really frustrates me is it's based on the assumption, as you read the language, that this won't be important for people with disabilities. That just stinks. If you make an exception because this doesn't apply to a person with a disability, you're already creating a barrier for the person with the disability to even be affected or impacted or participate in that particular area. So that's why the whole exceptions thing, as you can tell, upsets me.
Good morning. My name is Anthony May. I'm an attorney at Brown, Goldstein & Levy, along with Eve, who I'm very fortunate to work with. My question for you today is specific to employment, and I'm glad Jennifer touched on it a little bit. I'm wondering if you think that the existing framework of the ADA and the toolkit is sufficient to address artificial intelligence and how it's being used in a lot of ways to disparately impact people with disabilities and exclude them from employment. If you think that framework is sufficient, and if not, do you think that it is up to federal, state, local levels to address those kind of potholes? I think for one example that comes to mind is in New York, you've got a recent law that just came out that requires, routine audits of systems that use AI in hiring. So are those the sorts of things that we should be looking for at a federal level, at a state level? Is it up to the local level? Or do you think that the ADA is sufficient?
Well, to some extent, the ADA is sufficient. So in that, we will be able to tell, and I'm not going to tell you how we're going to be able to tell, but we're going to be able to tell whether people are weeded, are screened out by these AI tools, for example, in the hiring context. But the problem is it's going to be a resource-intensive and difficult thing to figure out how this black box weeds out people with disabilities. And we shouldn't have to go through that process again. So I do believe that there are additional requirements that are needed for audits, for opportunities to ask for a reasonable accommodation, for information for people to know that they're being tested by an artificial intelligence screening mechanism, for all those things that we've been talking about in what are called now best practices, but that do need to be incorporated into federal regulation, so there's consistency across the board. And I've been thinking about this in the hiring context in particular, but it also plays out in they're screening people for benefits using AI. And so there are going to need to be tools beyond just looking at the results that show discrimination, because at the time when you look at the results, the damage has already happened. Yeah. And we need to stop the damage from happening by conducting audits, by using the data. What do they call it? Pushing the data so that you bend the AI towards inclusion of people with disabilities instead of exclusion, and making sure that there are notices and opportunities to opt out and seek reasonable accommodations, just to name a few.
Yeah, and I would just add, I think this is an evolving area where the technology is evolving so rapidly and the uses of it are changing, so that I know there have been efforts across the federal government to regulate in this area or to do guidance in this area. where it actually was quite complicated once people got into it because everything is changing so fast. And so, all of the efforts to kind of identify a particular set of practices, I think, didn't necessarily account for all of the things that were happening. And so I think that, some of those efforts resulted in sort of early efforts to just do a more high-level approach, but you're going to see as time goes on and there's more enforcement, and some of this, I think, is going to get litigated through enforcement measures before there are clear guidelines about exactly, what the ADA and other civil rights laws may prohibit and allow. You're going to have to see it, I think, attached to some sets of facts, but it is because of the pace at which the technology is evolving that's made it, I think, somewhat challenging to sort of do comprehensive guidance up front. And so you're going to see more and more as things go on.
Okay, we only have 18 seconds on this countdown clock. I wanted to give everyone a chance, just one sentence on what you would like this audience to take away from our topic of what's happening in the federal legal space.
Keep pressure on the federal government to do what's right and to do what needs to be done, and don't wait.
Sachin?
I echo what Eve said, hold us accountable, because if we don't hear from the public, we just assume it's all good.
Anil?
We've got to push the message that people with disabilities are value added and not an extension to something else, and that way they can recognize that as we make it inclusive, it's better for everybody. It's not just for people with disabilities.
Jennifer?
Everything the federal government has done has been really because of the advocacy of the community of people impacted, and so that advocacy matters, and please keep doing it.
And my takeaway is digital accessibility is a civil and human right of disabled people. Whenever you're thinking about the law, looking about the law, talking about the law, put people with disabilities front and center in that conversation. Don't forget the civil rights. Thank you so much for being such a great audience.
Do you know whether anyone